Hi, everyone. My name is Jane McElligott. I teach for the Legal Studies program at Purdue University Global. And I'm here to discuss opening statements and closing arguments. And so this will help with the PA 335 class on courtroom and trial presentation, as well as it comes into play in criminal law, at least near the end of the class in Unit 9. So let's get started here. So opening statements, and you notice the different terminology. So it's opening statement. So it's not an argument at this point. It's more of the lawyer setting a roadmap of what will be shown in the trial. Closing argument, however, is the final argument of the trial. So an opening statement is the counsel's chance on each side to make a positive first impression. That's an important part. It's the first time the jury sees the attorney. It's important to make that very first impression be good, because as this quote says, you never get a second chance to make a first impression. And besides that, it's a chance to tell the jury the themes of the case, what the case is all about from the point of view of the plaintiff and the defendant, if it's a criminal case, the prosecutor and the defendant, and really explaining why the jurors should return a verdict favorable to each party. So the opening statement, it can have a powerful influence on the verdict because it really sets forth that framework at the very start, in which jurors will start to evaluate the evidence, the parties, and the lawyers really for the rest of the trial. So it's a key starting point in the trial. Just a little bit on the rules relating to opening statements. So there's no inherent right for counsel to give an opening statement under federal or state law, but it's really in the discretion of the trial judge, and judges will permit opening statements because they recognize the importance of allowing each side to provide that roadmap or preview of the case from their point of view, and talk about the issues that the case presents, the evidence that will be presented in each side's position. So it's an important stage. Usually trial judges are very lenient on allowing counsel that time. But sometimes judges, want to keep it in check, the time in check a little bit. So sometimes they will set a time limit of, say, 10 minutes to 30 minutes for each side. And the thing about the opening statement, it must refer only to evidence that is likely to be admissible. So if counsel doesn't think that evidence is going to be admitted because of some kind of constitutional issue or error by police, then the counsel, before they even mention it, should ask for a ruling on the admissibility of the evidence ahead of time to make sure that that's not going to be an error that may be reversible error that might turn the whole verdict around. That's called a motion in limine. It means in Latin a motion at the threshold of trial. So counsel can get a ruling if some evidence just seems a little bit questionable whether it's going to be admissible or not. They can get that ruling before the trial starts to avoid any issues before even mentioning it in the opening statement. That's the safest approach to take. If you've probably heard of the famous trial lawyer Jerry Spence. His quote on opening statements and their power is that you can have the greatest close in the world, but if you haven't won the case by the time that you get to the close, it's too late. The opening statement is where you win the trial. So very powerful there, that you could even, with a powerful opening statement, you can really be on a winning track. Now, some jurisdictions do require opening statements to establish what's called a prima facie case. So, in other words, counsel, if it's a criminal case, as the prosecutor would have to set forth the elements of the particular crime being charged and show how the evidence establishes each of those elements. in those jurisdictions that do have that requirement, counsel should identify the elements of a claim or defense and then explain how each element will be proven. Um, and then, of course, while the opening statement can identify the elements of the cause of action, if it's a civil case or a defense, um, it should not get into huge detail, lengthy quotations of relevant law or complex explanations. It should be very simple, to the point. It's kind of like an introduction to a book. An introduction usually doesn't get very complex. It's sort of an introduction to what you will be getting into in the book. So lawyers shouldn't argue the case in the opening statement either. They should focus on what will be proven through expert testimony and evidence as the case goes along. But there's nothing really to argue at this point because there's no evidence having been admitted yet. So it's just kind of a preview of this is what will be presented, and that provides the jury with a good outline of what is to come. On the burden of proof, so in criminal defense opening statements, defense counsel is able to point to the fact that the prosecutor has the burden of proof to prove that the defendant committed each element of the crime that's alleged beyond a reasonable doubt. So they can emphasize that very high level of burden of proof that the prosecution has. In civil cases, counsel should be sure and make clear it with the judge first as to whether they can mention the burden of proof in a civil case. Remember, in a civil case, it's by a preponderance of the evidence, but it's not a given that they can get into that burden of proof if it's a civil case. And there are the different burdens of proof there in that chart. If you think of, as I mentioned before, an opening statement is much like an introduction to a book. You could even think of it as the cover of a book. This is one of my favorite books, Gideon's Trumpet, that tells the story of the defendant in Gideon versus Wainwright and how he was, poor and in prison, and how he wrote this powerful, in his own handwriting, this powerful petition to the Supreme Court that eventually led to the constitutional right to counsel under the Sixth Amendment. So the book, the cover of the book can kind of say a lot as to what the book contains, and it can get you kind of psyched up to get into that book and start reading it. So that's how you can think of the opening statement, as this forecast almost, designed to provoke a general understanding, provoke further interest, just like the jacket of a novel. So the jacket text, it captures the essence of the book in a way that gives the reader a general sense of the book's theme. It entices the reader to proceed further, and it leaves the reader to make his own judgment regarding the final meaning of the story. So you don't tell the whole outcome, you just say, this is what we're going to get into. And that's exactly how jurors should be left at the end of the opening statement, with this understanding of what the case is all about, what the theme is, an eagerness to learn more about what happened, and an appreciation for the ultimate judgment that they are going to be asked to make in the case. Now, to be effective as an opening statement, lawyers have to remember not to get up there and just start, saying, oh, thank you for staying, thank you for coming in today. We appreciate your service as jurors, because that's just going to bore the jurors, and they'll just tune out. So it's essential at the very start of the opening statement to say something that captures the audience, the jury. So for example, this sample one says, members of the jury, this case is about two things: failure to yield the right of way and a shattered future. And that just kind of like, whoa. And that gets the jury thinking. And then it goes on to briefly tell the facts. On June 1st, 2020, the defendant failed to yield the right of way to Ms. Anderson's car, made an illegal left-hand turn, caused the crash. That crash broke Ms. Anderson's back, destroyed her health, and shattered her future. So just very short, concise, but powerful, and it's said in a way that the jury is paying attention at this point. And that's what the idea is. You capture the main point of the case, and you meaning as the lawyer, dramatize, humanize, and organize in a way that it draws the jurors into the story, engaging their hearts and minds. So not only their minds, but their hearts, empathy, compassion, hearing something like that, so that they can see what happened from your point of view and develop a preference for your side, because of course you want the jury to see it from your side of the case, the client's side of the case. And I love this quote again. Jerry Spence, the famous trial lawyer, said, "In our hearts, we love to hear and to tell a good story. Stories well told are the engines by which we win." And that really is what the opening statement, and as we'll see, a closing argument, is really that story capturing the facts of the case in a way that it captures the attention of the jury. The other part of opening statements, and as we'll see in closing arguments, is that visuals are an essential companion to the statements by the lawyer. Just as from seminars, you don't want to just hear someone lecture. You want to see a PowerPoint or maybe a video. It helps so much to combine the video aspect along with listening to a lecture. So using visuals during the opening statement, it accomplishes in a few moments what might be impossible or unwieldy by speaking alone. So, and studies show this. Studies show that individuals can recall pictorial information with far more ease than speech. So seeing a visual such as a PowerPoint as the attorney is giving the opening statement, or maybe if it's a car accident case, maybe a chart of the accident and how it happened. That visual can help a great deal to keep the audience focused and to help them understand what really happened in the case. And that's what the lawyer has to make sure, that the visual focuses on a key aspect of the story being conveyed, and also that it's easy for the jury to grasp. If the lawyer puts up this very complex, accident chart, or maybe if it's some very complex type of case, like a trademark, a patent infringement, and they have all these, very, very detailed map up there, it might just wreck the enthusiasm of the jury to keep listening. So it's important to keep it very clear, concise, and simple, in the sense that you're giving this nice overview of what the case is all about. So sometimes lawyers make the mistake of having this very impressive visual, but it's not to impress the jury. The whole point of it is to guide the jury with this nice big picture, so that you can simplify the complex issues in the case. So it's all about simplifying, making it clear, setting forth what is to come. And most courts, most trial judges are very liberal about what they allow counsel to display as far as either actual evidence. So if it's a criminal case, they could actually show the gun used in a murder, for example, or demonstrative evidence, which is, for example, it demonstrates what happened. So it could be the accident scene chart or a crime scene diagram. So courts find that if the attorney can describe a piece of evidence during an opening statement, then why not just allow the attorney to show the item of evidence instead of describing it? So it just makes sense. And trial courts have discretion to rule on the conduct and scope of opening statements, and the rulings are usually upheld on appeal too, because again, trial judges have a lot of discretion. They have wide latitude in presenting, they tend to give wide latitude to counsel to present their opening statements, and they depend on the good faith of the lawyers to be ethical and to do the right thing. So they're confined, just as they're confined in what they say in an opening statement. They can't go start saying, the defendant is guilty and just make opinionated statements like that. They also have to make sure what they're displaying is ethical and in good faith as well. So both anything that is visual to accompany the verbal opening statement has to comply with the same ethical rules, and it also has to be evidence that should be admitted into evidence. And again, if they're not sure it's going to be admissible in evidence, then they should first get that ruling to make sure they're not going to make some error that would make the trial the verdict reversible. Example of of counsel going too far, prosecutor going too far in the opening statement. So this is a case from Nevada in 2013 that is typical of cases where lawyers have gone far too far with their opening statement and the visual. So Waters, the defendant in this case, he had gone on a crime spree, quite a crime spree. He stole a car, he crashed it, he stole a second car, he led police on this high-speed chase. He finally ditched the second car, and it all ended when he started running into a store and police let the police dog go after him and he bit him on the leg, and that put an end to it. So quite a case. So the prosecution charged Waters with possession of a stolen vehicle, grand larceny of a vehicle, and failure to stop for police. So at trial, the prosecutor displayed a PowerPoint during his opening statement to the jury, and one of the slides in the PowerPoint had Waters' booking photo, so his photograph from the booking, and it had guilty written in big capital letters right across his face. So prejudicial to say the least. So while displaying the guilty PowerPoint slide to the jury, he added to it by saying, so after hearing the evidence in this case, we're going to ask you to find the defendant guilty on possession of stolen vehicle, guilty on grand larceny auto, and guilty on failure to stop on a police officer's signal. So defense counsel in this case, again, that was the prosecutor saying all that. Defense counsel had previewed the PowerPoint, had a chance to do that before trial, and made an objection and said, no, that slide with guilty across my client's face and his booking photo, this is objectionable. I want to keep that out from the jury's view. But the trial judge said, nope, I don't find anything objectionable about it. The trial judge pretty much said, oh, this happens all the time, no big deal. The jury convicted Waters of the crimes he was charged with, and he appealed all the way up to the Nevada Supreme Court on the ground that the guilty slide, the booking photo with guilty on it, undermined the presumption of innocence essential to a fair trial. And remember, this is the opening statement, and that presumption of innocence should be something that is, emphasized at that stage. And so in reviewing the trial court's ruling in this case, the Nevada Supreme Court explained that a prosecutor can use a PowerPoint to accompany their opening statement, but that's only so long as the slide's content is consistent with the scope and purpose of opening statements and does not put inadmissible evidence or improper argument before the jury. And the court added too that a PowerPoint can't be used to make an argument visually that the prosecutor couldn't have done orally. And that's what happened in this case. So the Nevada Supreme Court said that defendant's booking photo with guilty across it is just way out of line. It constitutes improper advocacy, undermines the presumption of innocence essential to a fair trial. So basically, he was denied a fair trial because of this slide in this shown during opening statement. And so the Nevada Supreme Court reversed the defendant's conviction and ruled that the display of the defendant's guilt was was the impermissible expression of the prosecutor's personal opinion on the defendant's guilt, which undermined the defendant's presumption of innocence. So a good ruling in that the prosecutor didn't get away with that because he's really stepping on the jury's shoes and telling them this guy's guilty before they even have the chance to look at the evidence. Um, so we'll step into closing arguments. So again, the opening statement is at the very beginning of trial when it's a preview of the case to come. Closing arguments are at the very end of trial when counsel on both sides wrap up the case, they wrap up their arguments. And so there's a little procedural stuff here that in criminal cases, this criminal procedure, Federal Rule Criminal Procedure 29 governs the order of closing arguments. And as the prosecutor goes first, then defense counsel, and then the prosecutor has a right of rebuttal after the defense counsel goes. On the civil side, the Federal Rules of Civil Procedure actually don't mention closing arguments, but trial judges will give the leeway to the parties to help them kind of explain what the strongest argument, the strongest evidence is on both sides. And it helps the jury in their deliberations. So trial judges, again, still have a lot of discretion when it comes to closing arguments as well. They may impose time limitations just as they might with opening statements. And usually it's a little bit longer than the opening statements, but it will range from, say, 30 minutes to 60 minutes for each side. And, if it's a very complex case, it may be 60 minutes because there has to be time to kind of wrap up all this complex evidence. So federal and state law, the case law set forth the rules governing closing arguments, and as well as the visual aid. So it's really mostly in case law. And so closing arguments must be based on admitted evidence that was actually admitted during the trial. So if one side decides to go a little bit rogue and mention evidence that was not admitted, say it was a violation of a search and seizure violation, and the court rules that certain evidence is not even admissible, but the prosecutor mentions that in the closing argument, that could be grounds for a mistrial, especially if counsel intentionally points to evidence that they know was ruled inadmissible. Also, a statement by the prosecutor regarding a criminal defendant's silence, their failure to testify. So if the prosecutor says, "Oh, we can tell this defendant is guilty. He didn't even get up on the stand to defend himself." That's grounds for a mistrial because it infringes the defendant's right to remain silent. The defendant doesn't have a duty to get up on the stand and defend themselves. They can remain completely silent, and that's a key part of our adversarial system, and they can't be criticized for making that choice. So another limit on closing arguments is that lawyers are not allowed to state personal opinions during closing arguments or try to vouch for the credibility of some of the witnesses or the lack of credibility of witnesses. And this is set forth too in ABA Model Rule, the Ethics Rules, Professional Conduct 3.4E, that states that a lawyer shall not assert personal knowledge of facts and issue or state personal opinion as to the justness of the cause, the credibility of a witness, the culpability of a civil litigant, or the guilt or innocence of an accused. Because the problem with that is if the lawyer is giving their own personal opinion or making some kind of direct appeal to sympathy or prejudice or other passions, it's improper because it's stepping into the ground of the jurors. The jurors are the ones to make those decisions, to decide what evidence is credible. And if lawyers start spewing out their personal opinions, it's taking away from the role of the jury, really. And they're also, by pointing to some type of sympathy or passion or prejudice, they're asking the jury to base their verdict not on the evidence they heard during the trial, but really more on something other than that, on just, for example, if the prosecutor argued that the jury has a duty to put the criminal defendant behind bars to protect their community. Um, it's not right for the jury to be making their decision, their verdict based on, oh, this guy seems dangerous, we're going to want to put him away, rather than based on the evidence that was presented in trial. So that can be grounds for mistrial as well. And closing arguments, just like the opening statement, should start out strong and make that impact, get the attention of the jurors. Again, because just thanking the jurors for their service, really appreciate that you sat through this trial and blah, blah, blah. That's just going to, again, tune out the jurors, and you want to keep them paying attention. So, again, get the jury's attention in that very first minute or two, even the first few seconds, by summing up the heart of the case. For example, 1 second, that's all it takes to ruin a life. I mean, who wouldn't perk up and start listening at that point? So any evidence admitted during trial, witness testimony, key jury instructions, and visual aids can be brought in and used during the closing argument. And visual aids such as a PowerPoint poster board with pictures should really be weaved into that closing argument, because you want to bring the evidence, the arguments to life. And what better way to do that than to bring in visuals, whether it be the actual evidence or demonstrative evidence like charts or diagrams. Just one case on to show, just as in with opening statements, they can be prejudicial. This case is an example of a prejudicial closing argument, mostly because of the PowerPoint slides, much like in the opening statement case we saw. But in this case, is a Washington State case. The prosecutor went far beyond the bounds of zeal and committed serious ethics violations that ended up reversing the defendant's conviction. So defendant Walker, he was convicted of first-degree assault, first-degree robbery, solicitation, conspiracy, because he was involved in this armored truck robbery at the Walmart where his girlfriend worked. So he had asked his girlfriend to keep him updated on the daily receipts on the armored truck that would go to Walmart. And so she told him, hey, today it's $207,000. And so he decided, hey, wouldn't this be easy money? We'll go get $207,000. So he created this plan with his cousin and his friend to go rob the armored truck. Well, the cousin and friend shot and killed the armored truck driver, so it didn't go so well. They took off. They took off with the money. Walker remained in the car, and he then ditched the car behind an alley. So then they were all pretty, they caught up later, and they were all kind of sharing the money. But then police arrested Walker on his way home from Red Lobster, where he had splurged on dinner with his girlfriend and the kids, paid $200 in cash. He had stopped earlier in the evening and bought a Wii, other videos, a safe, probably for his remaining money, and his gun. And so the prosecutor used a PowerPoint slide to show how Walker splurged even after killing, even after his friend and cousin ended up killing this guard. So this is the slide. It's tough to see that picture, but that was a picture of the defendant with his family living it up at Red Lobster after this crime. And so all this, as you can see, this is prejudicial to the defendant. Defendant Walker guilty of premeditated murder. He's guilty, big letters, splurged on frivolous things, $200 dinner at Red Lobster, defendant purchased 2 safes. So again, guilty, so emphasizing his guilt all over the slide. And that wasn't the worst of it. Maybe that was one of the worst slides, but this was a huge PowerPoint presentation of 250 slides, and 100 of them had the heading, Defendant Walker guilty of premeditated murder. And so two slides had this heading, Defendant Walker guilty of assault in the first degree. 3 said Defendant Walker guilty of solicitation to commit robbery. So there's no doubt in this PowerPoint, it's just flashing guilty left and right. And it also said, there was one slide where it said guilty beyond a reasonable doubt in bright red letters superimposed over his booking photo. So much like the opening statement case we looked at. There was another slide that had a photo of the victim, who was the armed truck driver who was killed, with again a superimposed heading that said defendant's greed and callous disregard for human life. And then they put details there on how much money they had stolen and how they distributed it and used the money. Making it say they killed this guard to be so frivolous and go to Red Lobster. So really playing that up in the PowerPoint. Now, for some reason, defense counsel, I don't know if defense counsel was sleeping, but failed to object to this PowerPoint presentation. And that's a major error. It should always be objected to at the trial level so the judge can rule and hopefully keep it out. Or if it somehow already got in, at least the maybe some remedy could be taken, such as the jury is to disregard, even though that's pretty hard. So the Washington Supreme Court, it went up on appeal to the Washington Supreme Court, and that court said that when a defendant raises prosecutorial misconduct, which is the alleged issue in this case, for the first time on appeal, the defendant must show not only that the prosecutor's conduct was both improper and prejudicial in the context of the entire trial, but that the misconduct was so flagrant and ill-intentioned that instruction from the trial judge would not have cured the prejudice. And the court said that they had no difficulty holding the prosecutor's conduct in this case was improper and really beyond the point of being cured. So defense counsel lucked out because the Washington Supreme Court was still willing to hear this case. And the court also made a little side note about the importance of PowerPoint presentations during closing arguments. And they said that, that's fine to use multimedia resources in closing arguments. It's a good way to summarize, highlight relevant evidence, and good trial advocacy, encourages creative use of such tools. Closing arguments are an opportunity for counsel to argue reasonable inferences from the evidence. However, advocacy has its limits, and a prosecutor has the duty to subdue courtroom zeal, not to add to it in order to ensure the defendant receives a fair trial. And in this case, the court said that the prosecutorial misconduct and prejudice was incurable to the point where, it was too late. What was shown to the jury, just the only way to cure it at this point is a mistrial, and the defendant has a whole new trial because it was just so highly prejudicial, this 250 slide PowerPoint. So defense counsel's failure to object will not prevent a reviewing court from protecting a defendant's constitutional right to a fair trial. So again, defense counsel was lucky because the court said objection in this case was not necessary because it's incurable prejudice. It's so bad that it's still going to be grounds for reversing this conviction. And so they gave the defendant, it was a mistrial, a new trial is the only way to cure this. And the court made a note too that to avoid this kind of really egregious misconduct by prosecutors with such prejudicial PowerPoints, and there's a lot of cases about this, the court suggested that trial judges preview the slides before they're presented. So even if the defense counsel doesn't insist on viewing the prosecutor's slides, the trial judge should do it. And if the judge has a printed copy of the PowerPoint, ask for each side to give a printed PowerPoint, it's not going to be burdensome for the judge, and it really could curtail major problems like this from arising and the need for a whole new retrial due to that misconduct. So that is it. So thank you for listening. There's some resources to check out, and I will go to the next slide too with just a couple of more uh, places you can check out if you're interested in digging into this a little more. Take care, all.